There are certain doors that are absolutely closed and locked to the attorney, in fact, and among them is the ability to change your will. They can't simply go in and decide that they're going. And those are things most people don't want the person that they put in charge of taking care of them while they're incompetent. They don't want them to say, "Oh, I think I'll rearrange his estate plan." So they can't do that. Good news there. So there are a few doors locked, but there are a few doors that are wide open. And the law says if you close this door, there will be consequences to a vendor, to a financial institution, etc.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. We're picking up in episode 2 of the third topic that we're dealing with on the subject of trusts and the key moving parts. You'll recall the first part we talked about was the trustee, what's the responsibility and the role of the trustee, things to consider about appointing a trustee, etc. We analyzed beneficiaries, who should you appoint, how you should appoint them, pros and cons of different provisions you can have regarding how to distribute assets to beneficiaries or to not distribute, or at least to do it over a long period of time. And then today, or these last 2 episodes, this of which is being the second episode, is the third part of that discussion and the second episode of that third part. And that relates to the assets, or what's called by lawyers the corpus of the trust. And that's kind of the center of action in many ways, because that is a discussion about what do you put in immediately, what do you wait and put in later for the reasons we talked about in the last episode. There are lots of things that you may decide you want to keep out of the trust for various reasons. We've tackled the main categories, a number of main categories already. So be sure to review those. And so today we want to talk about 2 other categories. One relates to insurance, and that'll be a fairly brief discussion, but it deserves separate discussion. And with insurance comes also the subject of annuities. And then we're going to talk about after that the part relating to tax-deferred assets. And that's a little bit of a longer discussion because for many people, the largest single component of their portfolio relates to the IRA, 401k, maybe a Roth. So we know that this is the center of action for many people. And it's funny, it's potentially the most complicated because you have the federal government involved in your decision-making more so than if there weren't these tax revenues that the government is counting on getting from you better sooner than later. So anyway, let's take on life insurance first. With us today, continuing this discussion, is Ben Zinkel, and he is with TuckerAllen, an attorney who practices exclusively in this area, as all the attorneys do at TuckerAllen. So you want to undertake the topic of life insurance?
Yes. As we discussed previously on the previous episode, there are several ways to fund your trust or put your assets into your trust. One of those is transfer on death designations. Likewise, with life insurance, you have beneficiary designations. And what a person can do with a beneficiary designation is they can designate who they want their life insurance policy to go to or to pay out to after they pass away. You can put individuals, but you can also list your trust as the beneficiary designation. And there are some benefits in doing that as opposed to just listing specific beneficiaries. The first one is that if you just list specific people on your life insurance for your life insurance payout, they're typically only listed in sequential order. So the primary beneficiary would get everything, and then the secondary would get it if that person predeceased the person who put who has the life insurance policy. So some are different. Some you can split it out to your 3 children, etc. But if you list if a person lists their trust as the beneficiary to their life insurance policy, the terms of the trust will control where that life insurance policy goes. So a person would have more control over things. They can list out their beneficiaries, specifically who they want their life insurance policy to go to. Of course, all your remote contingent beneficiaries and things like that apply, and any rules that they put in their trust concerning continuing trust or lifetime trust, it would flow through that first. So it just does give that person a little more control over their life insurance policy by listing their trust as a beneficiary.
Yeah, and the problem, the elephant in the room in this discussion is that even if you want to go ahead and put your assets, your tax-deferred assets directly into the trust, you're going to pay a pretty big price, because the way that the IRS interprets this is a transfer in which taxes are due. So if you have a Roth IRA, then you're fine because you don't have taxes due. You've already paid those. But to the extent that we're talking about what is more commonly out there, which are the standard or traditional IRAs, as well as the 401k, then when you make that transfer, you're going to pay probably a ton of taxes. So most of our clients don't want to do that. I want to remind you that it's very important to us to get subscriptions. For you to press that like button is helpful, but the subscribe button is the most important thing to us. And, we don't sell a product on here. I mean, naturally, the show is sponsored by TuckerAllen, so we do talk about TuckerAllen. But to be honest with you, the efforts that we put into this show is something that is of personal value to us more than monetary, quite frankly. We do love to do it because we think that we're being of great value to many of you. Let us know that. You like us? Yes. But the most important thing we look at is subscriptions. We've had a number of clients who, perhaps one of the reasons they're doing their estate planning late in the game is that they've had a diagnosis. They know that the money is something that they want to have access to sooner than later. So they know that even though they may pay the taxes sooner, that it's important for them to have the funds, and they want it to also have the benefits of being in a trust and having that versatile plan that you can only have with a trust versus a beneficiary designation, which is going to have, in almost all cases, will have something with the simplicity that Ben was just describing. Well, you may have much bigger and better ideas for how you want the money managed over time. So you definitely want your money in the trust. Now, you can do that, as Ben mentioned, through a beneficiary designation where you name the trust, so it does end up there when you die. But sometimes we've had more than one client who's at a point where they need the money sooner than later, so they go ahead and move the money into the trust, knowing that they've sped up or accelerated this tax by a few years, but they know that they're going to spend that money for healthcare reasons. They're probably somebody who doesn't qualify for Medicaid, so they have these assets that Medicaid, remember, they count tax-deferred assets. Medicaid counts virtually everything of any significance for purposes of whether you qualify or not for skilled care. So somebody who's looking at very expensive skilled care and they have assets, and most of their assets are their 401k or IRA, they just simply say, fine, I'll go ahead and cash it out now rather than cash it out over the next 2 or 3 years, and I'm going to put the money in the trust. And if I die tomorrow, I know that it's subject to this great plan that I've developed, this elaborate. Remember, we talked about earlier in this series about these dynastic, multi-generational plans you can have, even if you're not a millionaire. So they can have the peace of mind of knowing that they've put it in the trust. It's subject to this rules. So if they make it for the 3 or 4 years that they hope, then they're great. And if they don't, that's okay too. But generally speaking, if you're not in one of these exceptional situations, you're going to want to have your tax-deferred assets to stay outside the trust and use the beneficiary clause, beneficiary designation that Ben just referenced. So that is what I think most of you will choose to do. And just to make crystal clear why you don't simply use a beneficiary designation of your loved ones as part of these assets, you give up such an opportunity that we've talked about so much on this show. I mean, incredible opportunity to build in these marvelous protections that you only afforded through an avenue like this, like a trust, where you can protect your children and grandchildren from some of the biggest risks that are out there. If I were to ask you to name, what do you think are the biggest hits that can likely happen to people as they get older? And some of these are mistakes that people are vulnerable to themselves, mistakes of their own making. Others are things that are just hovering out there, and you can run into them around any corner. But these are real risks. I think that we'd probably name, I would name, that business failure, economic crises that can happen to any of us, really. I would name also health crises and the creditors that might accompany that. So you could lose a fortune by having somebody who's not eligible for government health care, and you have a catastrophic medical circumstance, whether it's a traumatic event or a disease. It could eat through everything you own. Divorce. If you think your children or grandchildren or great-grandchildren will get married, and I'm sure you all hope that they do and that they marry correctly, but it's a risk. So those are just a few things, not to mention you can dispense it in a way that you think is consistent with the needs and the judgment of your loved ones. So that's generally the approach that we take with tax-deferred assets. So the last topic that we want to talk about, and this is kind of a more comprehensive topic that really spans all of the assets that we've discussed when we talk about the corpus of the trust. And that's, what are the things you need to have in place to assure that what you want to happen when you're gone happens? So usually when the trust is being created, those initial decisions, you're there and you're participating in those. So as long as you know what you want, and if you have a good lawyer like TuckerAllen, if you have a good lawyer, they're advising you and you're making decisions. Normally that's not where things go awry when they do go awry with estate planning. Often it's not that point, it's the point later where you've passed away or you've become incompetent. It could occur at that earlier point where, some event has happened and you've gone from in charge, running your life and knowing all the information about where your assets are and your passwords and all that information, to suddenly, you can't cooperate or participate, right? You're now strictly a spectator in your care, in the care of someone. That person at that moment, someone needs to be in a position to be able to access all the things that's important to you. We've talked a lot about the fact that, they have to have the authority. You got to have the authority. The show stops. No show begins for your care until they get this authority. So we've told you how to get that and make it happen just like that through your trustee and your attorney, in fact. But now that they have the legal authority, what are the practical things? What are the tactical stuff? What is the tactical stuff that you need to take care of so that they can swing into action? They have the authority. If you've done the things we've talked about on this show, during this series as well as before, we've assured they have the authority. The question is now, can they, in an efficient way, swing into action and take care of things according to the plan that you have already laid out? So that's what we're going to take a few minutes here and talk about. Ben, where do you want to start on this topic?
I'll start talking about safe deposit boxes. These are boxes at a bank that we all know about. If you want to put personal things in there, deeds, that sort of thing, in a safety deposit box.
Jewelry.
If jewelry, yes. If a person has a safety deposit box and they pass away and they don't have anybody on the authorization list but themselves, it's a hassle for the trustee to go to the bank and try to access that box. Typically, you have to get a court order to access that box if you're not on that authorization list. So something to keep in mind, if somebody does have a safe deposit box, they should probably add their trustee and their trust to the authorization list. That way, that would cover all the successor trustees, et cetera, there. I can go ahead and talk about digital assets as well.
Well, yeah, before you go to that, and also if you have a durable power of attorney, then you might add that. Now that person may be the same as your trustee, as we've talked about, but be sure that whoever holds a durable power of attorney too, if it's a different person, you might want to name them as well as your trustee. Now let's shift over. What were you were going to talk about digital assets?
Yes. So something that is important is most of us have a lot of our life on our phones and on our digital accounts these days, the financial things being the main one, but things such as photos and sentimental things on people's phones that they'd like their loved ones to access after they pass away. Or more importantly, if they do become incapacitated and they don't have control over their life anymore, and they need somebody to access something quickly, say they need to have a bill paid or need to contact family members. If your power of attorney or the person that's in place to take care of this person's things when they become incapacitated, if they don't have the password to their phone or passwords to their accounts or anything, they can't access any of that. We did some research into it and called Apple, called Google, all of these technology corporations, and especially for powers of attorney, they don't allow powers of attorney to access passwords or anything. They do have programs. Apple has something called legacy contacts that you can designate your legacy contact on your iPhone. What will happen is that after you pass away, that your legacy contact just has to have a death certificate, and they can send it to Apple, and Apple will give them access to that person's phone. But like I said, that's only after somebody passes away. During incapacity, they don't allow anybody to access passwords or phones, which makes it vitally important to have your passwords, your phone codes, your unlocks, everything in a place, preferably with your trust documents, for your trustee and for your power of attorney to access should you become incapacitated and upon your death.
Yeah, that's huge. That's interesting. So I'm pretty confident that if there were a court action filed, that ultimately you could force any online company to disgorge information, including these platforms that do business in every state. They do business in the state of Missouri and whatever state you're in. The problem is that it defeats the purpose, meaning that the Durable Power of Attorney Act was put in place to streamline people taking care of their needs when an emergency arose, and they're still alive. Remember, durable powers of attorney are when you're still alive, not when you're dead, when you're still alive. They expire. The authority expires, except to clean things up maybe, and they're allowed to do that related to a sort of getting your affairs in order immediately after you pass away, transferring assets maybe to an appropriate person, et cetera, but nothing more than that, and then their authority ends. Unlike a trustee goes on in perpetuity. I mean, if you have beneficiaries alive, the trust can stay into effect for 300 years. So the idea, though, that such a critical information, as you just gave examples of, online with Google and other websites where critical data is stored, that they can simply say we're not going to honor a document that exists in every state. Every state has some counterparts. It's a Uniform Powers of Attorney Act. And it is designed to require businesses to be responsive to these documents, to not require unreasonable information. So it specifically says to businesses that, this person will have the authority to do these things, and it lists some things they can't do under law. I mean, there are certain doors that are absolutely closed and locked to the attorney, in fact, and among them is the ability to change your will. They can't simply go in and decide that they're going to. And those are things most people don't want the person that they put in charge of taking care of them while they're incompetent. They don't want them to say, oh, I think I'll rearrange his estate plan. So they can't do that. Good news there. So there are a few doors locked, but there are a few doors that are wide open. And the law says if you close this door, there will be consequences to a vendor, to a financial institution, et cetera. So, and that's because our society and economy has a built-in interest. The state of Missouri and all other states have a built-in interest assuring that things can get done when you're not able to do it in this aging society that we have. So the fact that platforms that hold in their records such crucial information as what you were talking about can simply thumb their nose and say, we're not going to honor a durable power of attorney. It smells bad. And so I'm not questioning the answer that you all got in your research. I'm sure the answer you got is the answer they give. But still, what's frustrating is that no one's going to take the time to file a lawsuit, because by then they would have solved it some other way, probably. So it's frustrating to me that they can take this position that other institutions, for example, you take the document of a durable power of attorney, your person who's acting on your behalf walks into a bank anywhere in the United States, even in a different state, and they're going to be obliged to honor that. Now, they can make you go through a few hoops, in fairness, when I think about another state. They can require you to go through a few hoops. So let me make my example for any bank doing business in Missouri. If they were to deny that, they would be in front of a judge that would be harsh, because this is a method that's been approved and endorsed and encouraged by the legislature of Missouri to help its citizens and its businesses. And incidentally, I should tell you that the counterpart of that is that they're largely protected if it turns out something's wrong with that. That's the other side of the coin, is that businesses are protected, meaning that bank, if somebody brings something in, there's a forgery, it's not really, not like they're, for example, they can look and see it's notarized, and it is required to be notarized. They can see that there's a notary there and what looks like a notary signature. They're not required to go any further. They have no duty. It's called a duty of inquiry. A business or a bank, especially financial institutions, they don't have a duty to inquire, quote unquote. Instead, they can look, they can see it certified, they can assume it's correct. If it turns out it's a big fraud, bank is not going to be penalized for that. They can't be sued for that. So they handed over $1 million to somebody who gave them this fraudulent document. That's okay. I mean, that the bank is not going to be sued. So that's the counterpart of this point, is that businesses, websites and other, where they allow access, they're protected because it is a two-way street. If the state of Missouri and other states say, look, businesses, you have to be willing to hand over this crucial information to people with durable powers of attorney. That's the way this world's got to work in the 21st century. Then they also say, here's the good news. Look, if you just check the essentials, if it looks like a valid signature, if you see that it's notarized, a few other things you might look at facially, and you can act on it. That is, unless you have actual knowledge of some sort of fraud going on, then you're protected. That really annoys me that they could force somebody to file a lawsuit, because I'm convinced they'd ultimately win, meaning the person who has the durable power of attorney would ultimately win. In any case, it is something, though, that is huge if you don't make arrangements the way Ben just described, and that's what makes sense, is put it in a central place. If you don't do that, then you have this wonderful authority that has a whole lot of power, but its power is for naught because it has no authority or no subject matter, I should say, to act on. It doesn't know where your information is. It doesn't maybe know where some of your assets are. Now, thankfully, if it's a trust, most of those assets are in the trust, and they're probably already, hopefully, being controlled by the trustee. So that's good news if we're talking about a trust, especially if this other person, your trustee, has been acting in control some already. Now, if you were the trustee, we talked about this in the first episode, if you were, or the first episode, but also the first item of this 3-part series. We'll have to come up. Justin, you're going to have to plan this better.
We'll title it appropriately.
So in any case, but if that person was already participating, then they have that information. If they weren't and you suddenly become incompetent, then the good news is your successor trustee immediately steps into power. All of a sudden you have somebody just at that moment in time that they're needed, they have the authority through the trust for everything that's in the trust. And they probably have in fairness, already a lot of information, a lot more than perhaps a person with a durable power of attorney, which might be your brother who hopefully lives across town, not across the country. He might, and that's not necessarily a deal killer, but hopefully across town. But still, he's across town. He doesn't participate in the details of your life. So if you're counting on that person you've named as the attorney in fact to be able to swiftly come to your care, to assume their post and to man it effectively, then they've got to have access to that information. They don't need it in advance, but they got to know where to get it. You know, that I was just thinking about the point you made about the safe deposit box. I wonder if, I know that'd be true of a trustee, what you described. I wonder, though, if the holder of a durable power of attorney would have to be allowed. I think they'd have to be allowed access.
I believe so, yes.
Yeah, if it's certified and all that. It's just an example of how, our legislature is saying, look, citizens of Missouri, if you want a mechanism that takes care of you in an urgent situation, then we're willing to create the authority. We're creating an instrument here. We're giving it all this power. You just need to go ahead and have it properly filled out, and you need to have it properly executed. But if you do that, we're giving you the means to take care of everything that you need to take care of, to have your life managed appropriately for the balance, however long it lasts, or your incapacity lasts. And it's up to you to take advantage of it. But it was appropriate that we close this episode by calling your attention to all this. I dare say that I would say the substantial majority of all the really useful information resides online for the majority of us. And so don't shrug off this concluding topic. It really is critical. And it's not just assets that are found online. It's information. And information means creditors. It means other priorities you have, things you point out I hadn't thought about with these photos. Geez, everybody's photos now are online. I bet I have 5,000 photos online. My daughter doesn't delete photos. So you can count on 5 different shots of any given topic, at least. I'm of the school of thought that says that when you choose a particular subject and it's basically the same shot trying to improve on itself, you make a decision then and there if you have time, if not that evening at the hotel or wherever you are, and you get rid of the other ones. Justin, do you have a position on this subject?
As a creative person, I agree. Plus, it's just more data to sort through and more data to store. And you have to sort through all those extra ones. So you're like, this isn't any better. But yeah, I as a very amateur photographer, I get rid of the bad stuff and only keep the good shots.
Yeah. And the ones I end up keeping are not so hot, but they're better than the rest. I think the mistake I make is I'm paying for my daughter's storage. That's it. Maybe if she had less storage capacity. So in any case, any concluding thoughts?
No, I think we've covered most of it.
All right. So I hope that this whole discussion has been helpful to you. We're big believers in revocable trusts, but use a revocable trust in conjunction with your durable power of attorney. We'll be back again to talk about similar, useful, and hopefully interesting subjects. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by TuckerAllen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.